be useful for the discussion. That is not about AI and not about the green energy, or not always, but mostly a small description. And also a third one, because I'm a judge in the function at the Court of Justice. Please understand that I cannot make no remarks or comments or whatever about the cases which was decided by the General Court and which are before the Court of Justice as a judge. And also I am sitting some cases that I should be very neutral and keep full confidentiality as necessary. And last but not least, I very apologize, but I cannot follow you in this conference due to my other duties at the court. Even today it was very busy time, but I have to back to my previous jobs. This is why very not so polite, I know, but it was a compromise with the Vice Rector, Professor Csehi. I would like to start the presentation of the ongoing cases. The first big group of cases from Acer goes back to 2020. But this is the nature of the law, what is decided 5 years before. They came to the General Court, first of the Board of Appeal at the Acer, after General Court, after the Court of Justice, that we have a time differences about 5 years. But this is the most, I would say, this is a package and very, very important group of case law which are facing of the judges. And it's probably also useful to see what is the real issue about the Acer cases. This is the Austrian Power Grid and others against Acer. This is a judgment of the General Court. It relates of the procedure set out by the European Commission Regulation 2017, which created a system, a transmitter system, an implementation of the platform to the national regulatory authorities. And the so-called manual frequency restoration and the automatic frequency restoration. I never thought that it's so complicated, even technically, but probably legally is also was a very important step to set up a common European solution. And Acer took a decision on those proposals for the manual and the automatic frequency restoration in 2020 January, and made a solution at a European level. But as happened usually, some transmission system operators was not so happy and brought an action against the Acer Board of Appeal before the General Court, and seeking annulment of the decision of the Board of Appeal. It's very important that the Acer's decision has already had an appeal. There was a preliminary review, legal review, and to go to the General Court, there has always some restriction. But in the decision of the General Court, it rejected the applicant's argument that Acer has exceeded the limits of its competence, adopting the decision concern. And also this question came back also in other cases, whether Acer's activity is limited and Acer's decision exceeds the competence or not. At that point, the General Court notes that under the regulation, Acer is competent to decide or adopt individual decisions on regulatory issues or problems having an effect on cross-border trade or on the security of cross-border networks, such as the automatic or manual frequency restoration methodologies, where the national regulatory authorities make a joint request to that effect. In the view of the General Court judge, it does not follow from those provisions that Acer's competence is limited to points of disagreements between the authorities concerned. The General Court rejected the applicant's argument that Acer's Board of Appeal had erred in law when it found that capacity management function was not imposed by ACERs but stemmed directly from the regulation 2017. The General Court clarified that capacity management is necessary for the proper functioning of the automatic and manual frequency regulation platforms, especially when several entities are designed to perform the required functions. From the legal perspective, the regulation obliges transmission system operators to continuously update cross-zonal capacity for balancing purposes. From a technical perspective, this continuous updating is a key input to the activation optimization function. Therefore, the capacity management is an essential function introduced by the transmission system operators themselves to ensure the efficiency and safety of the platforms in line with the regulation. Accordingly, the General Court upheld the decision of the Board appeal. But there is an appeal against this decision of the General Court before the Court of Justice, but is due to the logic of our system. This is restricted for if the General Court made legal error concerning the review of the legality review of the Board of Appeal decision of the ACER. The other cases also goes to ACER, also to the year 2020. This is 6 cases, was decided by the General Court. ACER adopted a decision in November establishing a methodology for sharing cost or redispatching. When overload occurs in the electricity network, the output of certain power plant is reduced or increased to ensure the electricity flows safely and efficiently to consumers, and counter trading also. To manage the overload in the EU core electricity region like Belgium, Germany, France, Hungary, and so on. Several national regulatory authorities, that not private individuals, the national authorities and also transmission operators challenged the decision. That it seems that for me that this is something which was decided, which is really touch the formal system of the national system. Arguing in this case is that ACERs improperly set a single threshold for loop flows, the flow that does not follow the most optimal path, but takes the detour through the network, often passing through the grids and other countries or zones. That it can cause unexpected overload and generate additional costs for network operators without analyzing each binding zone border. That it refers to the geographic area where the electricity price is determined at the uniform market price and the trading can take place without network overload and without assessing flows in the absence of structural overload. They also criticized the insufficient reasoning for the chosen method of flow decomposition. In other words, the method of determining to what extent certain flows, loop flows, contribute to the overload, hourly cost to be allocated proportionately. The General Court annulled the ACER's decision, as confirmed by the Board of Appeal, only regarding the improper threshold setting and lack of reasoning, finding that ACER did not comply with EU procedure and legal requirements. That not based on the technical aspects, much more from the legal, I would say, much more legal EU, more general legal aspects. According to EU law, in the first place, the threshold must be analyzed and determined for each individual binding zone border. Neither the transmission system operators nor ACER carried out the required analysis. That it was not properly prepared, the decision, with other words. ACER's determination of the threshold is based on a single threshold for all binding zones in the core region, so that no account is taken of the specific characteristics of those zones and of the borders between them. In the second place, the analysis is normally required to determine the level of loop flows that could be expected without structural overload was not carried out. In the absence of such an analysis, the threshold set by the ACERs cannot comply with the requirement that for threshold to correspond to the level of loops flow that could be expected without structural congestion. However, the General Court upheld the scope of the methodology and the prioritization of the loop flows over internal flows, ruling that these aspects were consistent with the EU law. Prioritizing the loop flows is not unfair, but logical, said the General Court, because they cause the majority of congestion and therefore bear the majority of the cost. This is a final decision. It's interesting, the General Court, because no appeal was submitted at the Court of Justice. A third case from Acer goes also to the year 2020, and the case was decided by also the General Court in 2024. And this case, the topic is the regional operating security coordination, the methodology for the core EU electricity region, defining how cost of remedial actions to manage congestion should be shared when congestion occurs in the network. According to the rule, the congestion mitigation action of all high voltage network elements must be coordinated regionally, not solely based on the decision of the local transmission system operator. The Polish transmission system operator challenged the decision. This was something which is really goes or affected the Polish system, arguing that the methodology was too broad as it required all remedial actions on 2020 kilowatt on higher networks elements to be coordinated regionally, limiting the transmission system operator's ability to manage operational security independently. The General Court dismissed the challenge entirely, ruling that Acer was competent to modify the transmission system operator's proposal and that the ROSC method complied with the EU law. The methodology does not prevent transmission system operators from ensuring network security. The General Court also noted that regional coordination may involve cost, but this is justified under the principle of energy solidarity. This is a final, yes, the case it's before us as a court of justice. Yeah, that means that the Acer cases, as far as I see, at the first level of the General Court level, the parties or the claimants try to also challenge of the technical aspects used by the Acers between the European cooperation, but it is very difficult to challenge it. That much more if the General Court annuls or challenge partially the Board of Appeals decision, which the attacked one, which is the targeted one, is much more from legal point of view, but taking into account of the European interest. This is why it's for the future is also important to see that Acer's activity mostly complies at the general view of the General Court for the European interest. But as I mentioned to you, some of them is before the Court of Justice recently that we have to wait for the final decision. The second interesting case it's a gas cases and also a direct action. This is a Bulgarian Energy Holding and others against Commission. The General Court made its decision October 2023. It goes back to the case 2018. When the European Commission fined the Bulgarian Energy Holding Group with 77 million euro for alleging abusing its dominant position in the Bulgarian gas market by restricting third-party access to key infrastructure, including Romanian Pipeline 1, the domestic transmission network, and the only gas storage facility in Bulgaria. And this is a competition law cases. Yeah. But it's very important from the energy point of view. The Commission claimed that Bulgargas hoarded capacity on the only viable important pipeline to block potential competitors. The Bulgarian Energy Holding Group appealed, arguing that the Commission failed to prove a refusal to supply and an anti-competitive strategy. That we are in the energy law, but within the competition law. And the General Court, which is a huge, I would say, it's a huge decision of more than 200 pages, the judgment heavy evidentiary burden on the Commission to prove the exact chain of events that would lead to the foreclosure of competition. The General Court accepted that the Romanian pipeline was an essential facility and clarified that ownership is not required for the refusal to supply. Control over the facility is sufficient. Although Bulgargas has exclusive use of the pipeline, and the General Court found the Commission failed to prove an abuse because the refusal to supply must be capable of producing non-hypothetically exclusionary effects. Only actual and potential competitors with serious plans to enter to the market count and purely exploratory requests do not oblige to a dominant firm to respond. The General Court further clarified that having exclusive rights to a facility is not in itself an abuse. The Commission must show that the conduct could actually foreclose competitors. There can be no refusal to supply if no access request was made. If access is requested, the dominant firm must respond reasonably and may set reasonable conditions. Concerning causation, the General Court emphasized that not all restriction actions are anti-competitive. The Bulgarian Energy Holdings temporary restriction did not limit competition, as Revise could not access to the only important pipeline for reasons not attributed to the abusive conduct. This suggests a counterfactual approach. The conduct is only abusive if it's actually restrict competition compared to scenario without. The General Court also considered that Bulgarian Energy Holdings public service obligation, concluding it was legitimate to secure a minimum gas supply. It applied the state action defense, exempting Bulgarian Energy Holding from liability when managing capacity on the Romanian pipeline. Finally, after its very, very detailed analysis of the case and the Commission's decision, the General Court annulled the Commission's finding all abuse in full by noting one isolated exclusionary act did not substantiate the alleged continuous abuse. The General Court also found procedural defects as the Commission did not provide Bulgarian Energy Holding full access to the evidence relevant to the alleged abuse and fine. The case now is before the Court of Justice due to the appeal of the Commission, and now I would say this is the not end of the decision. But once again, it's very, very important that how the General Court treats such a cases, energy cases from the competition point of view. And this is the well-known case, which is also back the second time to the Court of Justice. The basic of the case of the Nord Stream 2, you know better than me, the amending of the Gas Directive in 2019, and the Nord Stream 2 AG, which is a Swiss company but owned by Gazprom, is tried to challenge before the General Court and argued asked for annulment of this amendment 2019. But at the first round, the General Court dismissed the action as inadmissible, but due to the appeal of the Nord Stream 2, the Court of Justice annulled the General Court order, which for admissibility sent to the case back to the General Court. And now we have a decision of the General Court from 2024, and the decision that the General Court regarded the case on the merits and dismissed the action of the Nord Stream. Noted, saying the General Court that Nord Stream 2 invested in its pipeline knowing there was no guarantee that EU law would not be applied. It could foresee that EU institutions and several member states would extend internal market routes to pipelines from third countries. Given the progress of the pipeline in 2017, which is before of the change of the amendment of the Gas Directive, Nord Stream 2 could anticipate that it will not benefit from the derogation. Nevertheless, the General Court found that this did not prevent the pipeline from operating profitably. Therefore, the EU legislation did not violate legal certainty or violate protection of legitimate expectation. It was the major plea of the Nord Stream before the General Court. And also the General Court found that the derogation does not breach equal treatment. It was also a plea of the Nord Stream. And finally, considering the EU legislation discretion applying internal market rules to the Nord Stream 2 pipeline is proportionate, said the General Court. It prevents competition distortion and protects supply security, and the restriction on Nord Stream 2 and are not disproportionate relative to the objective of the directive. The case is pending now, it's before the Court of Justice due to the appeal. I don't think so that it's necessary to make any comments for the importance and different aspects of such a case as a Nord Stream 2 and the EU legislation. We have interesting preliminary rulings proceeding ongoing before the Court of Justice, and I will tell you. One is in a Hungarian case. It came from a Hungarian court. It's related a long-term capacity reservation agreement, which was signed 2008. The question was really that the former regulation, the 715/2009, which was replaced by the regulation 2017/416, which law should apply, whether the exemption clause of the new regulation, Article 35, paragraph 1, it's applied for the contracts which was signed before the new regime, the new regulatory regime. The question came from the Hungarian court because it's an administrative procedure. We started it in Hungary because the Hungarian Energy and Public Utility Regulatory Authorities made a decision saying that the exemptions clause is not applicable for the concrete contract, which was for a gas pipeline between Hungary and Romania, which was contract goes back, however, 2008, but the price which was fixed by the national law, it is made an exemption from the exemption. So does it mean that for this contract, however, is signed by 2008, the new regulation 2017 is applicable? No, the case is before the Court of Justice, whether the decision of the Hungarian authorities are correct, and to give a proper answer for interpreting the European law for the Hungarian courts who's reviewing of the case. We have other preliminary ruling procedure from Bulgaria. So you can see from geopolitical point of view, it's Bulgaria, it's an important field. It came from Bulgaria. This is also a competition case, but it's not an EU competition, but is a local, the Bulgarian Competition Authority. It's alleged that Lukoil companies abuse the dominant position by combining different practice. And some amounted to a refusal to grant access to an essential facility, others to restriction to trade. And Lukoil tried to challenge such a decision, Bulgarian decision, and the court, where is challenged the Bulgarian code, is made a preliminary ruling to the Court of Justice to interpret the European law. The basic is the infringement of the Article 102 TFEU. This is the basic rule, one of the basic rules of the European competition law. But rather, the most specific question, if the application of the Bronner test with public funding, the question which was raised by the Bulgarian court to the Court of Justice is if the dominant company receives public funding for acquiring an essential facility, must the competition authority still apply the Bronner test in refusal to supply case? It was one question. Or should the authority consider that the investment amount, the performance of the privatization concession contract, and whether the investment was required by the contract or made voluntary by the company? And we have also other cases from Bulgaria. What we know already that Advocate General Medina delivered her opinion this summer, early this summer, and she emphasized very detailed his opinion that the Bronner test remains applicable in cases involving refusal to grant access to essential facilities, even when the infrastructure was previously state-owned and later privatized. The test requires a case-by-case assessment to balance the interest of the competition, freedom of the contract, of the property rights. Here, the essential assets, which is owned by formerly a Bulgarian company, but which is owned by the Lukoil, and also it's very important for the port in Bulgaria. And the last one, which I would like to want to make a short reference, that also this is also probably a connection to the green energy. We have a pending case before the Court of Justice, and also where Poland brought an action against the European Parliament and Council and seeking for annulment of the Directive 2023/959. This is the amending the EU emissions trading system entirely. This is a huge claim, huge even cases. The main arguments of the Republic of Poland, that is the wrong basis on which the directive was adopted, Article 192, paragraph 2, instead of the correct provision requiring Council unanimity. This is the basis of the one that Poland states that unanimity was required because the directive significantly affects member states' energy policy decision. Poland states in his claim that the member states including Poland, were not properly considered. Energy solidarity was violated in European level, and Poland believes heavily on coal and other traditional energy sources. The expected ETS under Directive 2023/959 would impose significant cost on coal-based energy production. And third plea or third basis of the annulment, the directive imposed disproportionate cost relative to its objectives. And the fourth one, this is the censor cooperation violated. Poland's objection during the legislative process were ignored. And this is an ongoing case before the Court of Justice. And this is a very, I think this is all of questions very important, but probably for the new green energy strategy might be impacted of the decision of the Court of Justice, because this is a direct claim. It means whether the Directive 2023 it's okay or it's partially or fully annulled by the Court of Justice, that we will see in the near future. Of course, we have other cases in the energy, and also in small sense and broad sense, but I wanted to give you some overview what is recently before the Court of Justice. As you can see, we are judges. We are going back, looking back in the past, sometimes 5 years or even later on. But we have ongoing cases that's like this, the Polish case. So in past and present and the close future, we see how does it from legal point of view, pure legal point of view, from European point of view. We have a very interesting time for the energy lawyers. Thank you very much for your attention, and thank you very much. And that I have to leave and I cannot follow you. Thank you.